Welcome to the John and Rick Talk All About Insurance podcast, the show where two good old boys with over 80 years of combined experience pull back the curtain on what really works in the insurance world. Join John Smith, industry legend, marathon runner, and top producing agent for nearly 4 decades, and Rick Witcher, proud farmer, regional director, and lifelong relationship builder, as they share stories from the field, interview real agents, and show you how to build a business and a life you love. This ain't corporate. This is real talk from real agents, with a whole lot of laughs, straight up wisdom, and the occasional rabbit trail. Now, here they are, John and Rick.
Hey, welcome to John and Rick Talking Insurance. Of course, I'm John and
I'm Rick.
And today we're very excited. I've got one of my personal friends, a well-known attorney here in town, that we're going to involve him in some of these questions that we get. Mr. Aaron Chapman. Aaron, introduce yourself and tell us a little bit about you, would you?
Thank you, guys. Well, it's good to be on here. John, Rick, good to see you. I'm an attorney. I practiced law for 16 years. I practice mainly family law. I've at times had a general practice doing all sorts of different things: estates, probates, family, criminal defense, things like that. Mainly do family law, mainly see it in my practice. It's not just the law, it's really the family side of it. So we're dealing with families, and that's the calling, really. It's not, the law itself, it's one thing, but just being able to kind of apply that experience with these folks, who are in a family dispute or a family situation, that's really where our practice is. So my firm is called Lakeway Family Law. We're here in Morristown, Tennessee. We serve about a 50-mile ring or so around Morristown primarily. Basically, if you know anything about Tennessee, we go from Knoxville. We have cases right now. We have work in Knox County, and we have work up toward the Tri-Cities, and generally everything in between. And so that's really
We're
turf.
halfway in between, aren't we?
Yes, absolutely. And so it's a great location, and Morristown is a thriving community here, right in the midst of all of that. And so I grew up here. I've lived here since I was 10 years old. So, but that's the nature of my practice, and I'm happy to answer any questions or do whatever you need me to do.
I know I've known Aaron and his family for quite some time, and he's really highly thought of in town, not only in his practice, but as a good person as well. We always like having somebody on here that's good people. And he's also a big volunteer fan, Tennessee
Yeah,
Vols.
absolutely. And I'll be going to Mississippi next week for the Mississippi State game. So getting ready
really?
for that.
All
Yeah,
right.
trying to
Well,
find
you'll
my
be about an hour
earplugs.
north of my farm, Aaron.
Yeah, well, good. Well, we'll see.
Yeah.
And I think we're staying in Tupelo, and got a little late on the hotel, so having to stay up in Tupelo and go down, I think. But getting
I'd
ready.
be
Yeah, you won't
interested
miss
because
anything in Oxford.
you show up at just about every game, don't you, Aaron?
Yeah, we try.
You
Well, we
hit the
try,
road
and we
and
try to get.
everything.
Yeah, we try to. My dad and I, we have a goal of visiting all the SEC stadiums, and so that'll be our first
Great.
visit to Starkville, and not been to Oxford either.
Yeah, you
Probably
need
an
to come
opportunity
there.
there a little while ago. Absolutely.
And I know you were out there this past weekend when we were playing Georgia, and that was a nail biter. Man, I tell you what, that's one that I think we had some chances to win, but those kind of things happen sometimes. And but I'm still proud of them. I think that we've still got a good team, but we sure like to win that game.
Still processing that here.
Yeah.
And that's what you can say. And I'll tell you, there's a year that doesn't, me and my dad actually went down to Athens in 2016, and he was about to leave the stadium once that, if you'll remember this game, Georgia had taken the lead with about 5-6 seconds left in the game, and we got a kickoff, but they got a penalty. So we were at half field, midfield, and Josh Dobbs threw to Jawan Jennings a Hail Mary, and it was caught and ended the game. And that was the last time we beat Georgia. But my dad was actually, we were in the upper part of the stands, and we were walking down, and he's like, I'm going. I said, just listen, 6 game seconds. We're here. We're hours away from home. Just stay for a minute. And so we just stood there right next to the stairway and watched this thing. And in the stadium, it's different than TV. You don't have Vern Lundquist and all that yelling, caught. All you see is everybody in that corner, which was the student section, just drop down. And you knew at that point, and then you saw the balls run on, and you heard Rocky Top, and you knew we'd done it. And they shut the monitors off, if I'm remembering it. So you can see that happen. And I think this was a version of revenge for that, though they've had pretty good wins for the last 8 years as well. So we will get there. We will get Georgia off our back, John.
I know. We're pushing for it. Well, let's talk a little bit of insurance. Here's the situation that we need your expertise on, Aaron. We have agents all the time asking Rick and myself that are out there working with us and just work with other carriers about minors as beneficiaries. You know, everyone, when we sit down with someone, I'm doing a payroll deduction group, and the lady's sitting there and she goes, I want my son and daughter as beneficiary. And I say, okay, how old's your son? Well, he's 12. My daughter's
Mhm.
8. And they put them as beneficiaries. I think that we're running into some snags on that we've seen in the past. And just tell us your take on that. What do you suggest?
Well, I think it's a natural course for people to think like that, and that's generally a good thing. I mean, if people are thinking that, well, they're going to go into an insurance policy and protect their children, I mean, you'd say, well, golly, that's as good as you can get. You'd be surprised if they didn't do something like that. But the legal mechanics of it are sometimes very challenging. And I know when we've in the past advised people about their estate plans and to prepare their wills, people can be very one track. I'm leaving it to my kids, and we will invariably could stump them with one or two questions. It wasn't our goal, but I could sit right here at my desk and I could say, okay, well, what if your kids, aren't adults, by that point? Because I mean, people come in here, people my age, I have minor children, I have two girls. Uh, you know, People come in and they say, well, I'm going to leave it to my kids, and well, yeah, I think you're probably imagining that they're 50 and you're 70 or 80 or something like that. But what if this is next year? What if your kid's still in diapers? And so they'd say,
Aaron, don't tell us about what happens. Doesn't it have to go into probate? And the probate court kind of makes the decision if it
insurance
does go to the minors?
Well, insurance policies are a little different. And so here in Tennessee, we wouldn't necessarily courts are called different things. We have local rules that geared toward what it's called in a particular county and what county actually has the probate jurisdiction. It's very convoluted. And as I know, as a young attorney, I was often blown away that, in the neighboring county, Sessions Court was called probate. And then, here Chancery Court had probate jurisdiction. But probate itself is a term that really wraps up, and it's kind of a old timey idea of things that we deal with people and special matters. Previously, before juvenile courts became effective, you had probate court handled custody claims, for orphan children, things like that, adoptions, obviously estates, but just kind of those special family matters went into probate. And so you might have what you call probate jurisdiction or probate-like jurisdiction, but in reality, it might not be a probate case like a probating of an estate, because insurance generally, as you all know, would skip the probate process if the beneficiary is not the estate. And so you still have a court that has to do something about it, and you might try to find a way to consolidate that or loop that in with any pending estate over what the personal estate of the decedent might be, but you don't necessarily do that in a probate proceeding. And that doesn't simplify it, that complicates it. So what I'm going through there is tells you, this is the process. So go back to our example of, mama girl here sitting here saying, I'm going to leave, everything to my two kids who are 2 and 4. We say, well, you might do that, but what if that takes 4 years to get an order and then another 12 years to enforce that order with annual accountings, with involvement of the judge? What if you switch judges 3 times in that case? What if they
Yeah.
move counties? Things like that. Well, the mechanics of it don't look like, we just kind of want to get in, hit gas and drive the car. The mechanics of it say that engine has a lot to deal with before we get there.
Well, what would be the process? Let's say that you mentioned you have two young children. Let's say that that happened in your case, and don't like to think about it, but we all know that accidents happen where both parents are killed in a car wreck, and let's say the children are the beneficiary, they're
Hmm.
the secondary beneficiary. Then what is the process? What would happen? And I know it'll be a little different in different states and different counties, but basically, what happens at that point? The court awards the money, puts someone in charge of the money. Am I right?
Yeah, so typically that's what you would invoke guardianship under Tennessee law. And guardianship, again, is another term that means a lot of different things in different places. But in Tennessee, guardianship over a minor's property or over a minor is generally a probate or probate-like, chancery court or something would appoint a guardian for the children to manage their assets and their liabilities. Shouldn't have any liabilities, but to manage their assets and to could be that that's part of the custodial requirement. They would have custody. And I tell people, of course, family law, there's probably half a dozen ways to call custody under the law. It's not just like you go in and sign up and there's your custody. You can call it, there's several different species of that. Well, it goes like that. One of those is guardianship, and that's a process where you would acquire someone to manage. And the guardian, whoever the guardian is, doesn't necessarily have to be the same person who has custody of the child. Now, that would be natural for a lot of people, but in a lot of our previous estate plans, we'd have people, I want my kids to live with Aunt Lulu because she's so hands on and everything, but Uncle Bob's an accountant, and he's great with the money. So you do things like that. But yeah, typically the court could do that. From the insurer's perspective, what you see a lot of times is that an insurance policy is a contract, and fulfillment of that contract means that when somebody's dead, write a check. Okay, I mean that's the full execution on the policy. And so long as you've done that basic due diligence and followed what orders are there as to where it's gone, typically the insurer's out of it at that point. Well, what happens is the insurer wants to get out of it. The insurer doesn't want to be out there for 15 years in one of these stinkers. And so they will file what's called an interpleader action on the money side of it, on the policy. Say it's a $500,000 policy, and they'll say, listen, we're sitting here, we're holding $500,000 for these minor children, and we know there's a death and we had a valid policy, so we got to get rid of the money. So they'll file an action and actually force the court, say, bring in everybody that has an interest to this case, and let's figure out who's going to hold this money for these kids. And that's generally called an interpleader action. Very common in these situations where you have a mutual death or simultaneous death of the parents, or something like that, or a final parent, final custodian or guardian passes away or is terminated.
Well, that kind of brings into the deal of, when folks ask us, well, who should I make the contingent beneficiary?
Yeah.
They should be someone, and that's one of the things we'd kind of ask you about is
Mhm.
how do you make that decision? You know your family members, and you don't want to leave it to,
You think your family members.
well, but as best you can, you don't want to leave it to a potential someone that would gamble it away or whatever,
Mhm.
because how much I think that's my big question is how much control do they have? They basically have complete control of the money, right?
It depends on the structure of how the policy or the proceeds are left. And so under Tennessee law, and I'm not familiar with Mississippi or what other jurisdictions would
Right, I
be, but
understand.
under Tennessee law, you can have uh, a transfer under the Uniform Transfers to Minors Act, and that's the simplest process, but it's um, a little bizarre too. I mean, you can as simply as naming an account and naming a person proper to serve as a custodian of that account for that asset for minors. You have that custodianship established. Are they required to check into annual accountings? Maybe, maybe not, depending on the structure of that award. Are they required to do anything particularized with respect to the policy? Probably not. You probably don't sit down with your customers and your policyholders and write out, well, here's what we want to happen. If I die in April, here's what July needs to look like. You probably don't have that step. Okay. You're probably just getting a check. And there are horror stories. One horror story about a decade ago here, neighboring county to my county. Person, parent died, left benefits to a child, and I think I'm horrible with the facts on it. It wasn't my case, but an older half sibling or sibling got a hold of the money and or went to juvenile court. As a lot of people know, they'll go up to juvenile court, and I think it sounds like they just did their own pro se, fill out the application there. I'd like custody of this child, and dad has died, and got an order saying that they're the custodian of the child. Took that to the insurer in another state. The insurance company didn't know to interpret that or not interpret that as clear enough to issue the award, so they just sent her the check. Well, you can imagine where it goes from there. I mean, it was gone. So it went all the way to the Supreme Court. The insurer was held to have acted appropriately because they honored, what the law generally says is if you can't honor what the court orders say, then you're inviting insecurity into the whole court process. And so we got to uphold orders, even sometimes in another state where we look at them and in Tennessee, we'd look at them and say, well, that's junk. But, in Arizona where they did this, they might say, well, that's an order of custody. She gets the check. So that court might not have even had jurisdiction to fully give her those rights. That might have should have been something in probate court. But
Well, I've
that's
always
what,
heard when people die, people change. So those kind of
and
things
grief,
happen. quite a bit.
And that's how people grieve too. A lot of people don't realize that's how they are. But we kind of got we call them sometimes we. And I don't want to impugn anybody's situation because losing anyone is so hard and so monumental in someone's life. You just don't know. But sometimes we say we got greedier grievers than others. Okay, and it's not just that they were born unscrupulous. It just is something about that process, that justification. Well, he loved me more. You hear it all the time. I took better care of mama than my siblings. Why are they getting the farm and I'm getting, the storage building? So, things like that creep in. And you can imagine when a child is involved. And a big one that brings it on too is kind of his, mine, and our situations where we have later in life or we have a younger, someone has a divorce and they've got older children, but then they start a newer family and then they die. And so we have a lot of that goes on.
Do you have an idea of, well, like you said, I know I recall when my dad died, my my parents raised my brother's oldest son, and his ex-wife came and said, "When will the will be read?"
Yeah. That's actually not that's more of a thing of lore. We see a lot of funny commercials and, potato chip commercials and things like that where everybody's sitting around reading granddad's will, but there's generally no reading of the
Most of the time,
will.
there isn't.
Right.
Yeah.
I mean, a will is if it's a last will and testament, it's going to be brought into probate. It's going to be submitted with the probate court, and depending on your jurisdiction, there's multiple ways to probate a will, and there's a method to challenge a will, probate of a will. And we've been involved in those proceedings historically here. Don't do them much anymore based on just doing family law, but that's a whole process there. But yeah, I think people expect, and if I'm remembering right, we sit here and people say, "Well, they didn't even read the will." It's like saying you got arrested. Well, they didn't read me my rights. Well, that's not the whole story. And so probate of will, while it's a public action, public pronouncement, you don't take him into the corner and play the VHS videotape from 1993 where, he's sitting there and he made the will and it's not like that. Okay. I mean, the will's going to say what it says and you've got a method to challenge it. Plenty of them do get challenged on different theories. We won't have to go into all that here, but I think what we're really speaking about to kind of bring it back to what we do about leaving benefits to minors in these family situations is it can get real nasty and people don't realize they're going to do that. And we don't have the foresight. We don't have the foresight when we're making that decision. Decisions are very intimidating and we want to go. I think a lot of people will get sick and go to the doctor and they say, just do what you're going to do. I took my daughter to the doctor Friday for a cough and, we didn't go in for experimental treatment, just give her what you're going to give her and let's go, and so that people kind of want that in the law, but then you kind of have to stop them and say, what happens if one of your children dies before you die and the other one doesn't, or stuff like that. So we do a little logic check. I call it a logic check with people when we're planning, like make sure kind of a flow chart, and we'll draw it out, like what happens if you go here, but then here happens, we do that. And all that invites, a lot of scrutiny on who you name as your beneficiary and who you name as, you know, being in charge of that benefit if they are going to be a minor child. And also minority, you know, your what you would call in Tennessee the disability of minority, believe it or not. I mean you're underage is under the Uniform Transfers to Minors Act, that's 21 years of age. Everything else, the legal age of majority would be 18. And then an instrument can provide. I mean, you can leave a will and say, I don't want, Junior to get my account until they're
Certain
25.
age.
Yeah. And so, I mean, you can do things like that. So what does that age look like? Those are decisions people need to make and be thinking about. And the main thing is the insurer or the agent doesn't make those decisions for people. You need to determine whether or not you are a fiduciary in that moment or what the right thing to do, what the ethical thing to do is there, and not just be focused on getting that ink pen clicked and that policy sold. But, what is the goal here? Because insurance product, it's all about the goal. I mean, the goal is that the person leaves and their wishes were fulfilled under the policy and the obligations were fulfilled. And so you need to make sure that you're not just in a hurry there. Oh, well, just leave your kids and we'll deal with it later. What guidance, what counsel do you give to people? That depends on how far you're willing to go. But I think most people would feel most comfortable if they had somebody said, pump the brakes. We're doing an online mediation here, right in these chairs yesterday. And, we got the stuff in on the printer and, here comes my client grabbing the pen. Oh, whoa, whoa, whoa. I know. It's exciting. We've got paperwork, there's signature lines, there's an ink pen there. You want to do something. You want to do it. Like, let's wait just a second and go through it together. So, That's kind of how people are, especially when they're doing something like buying insurance. I would presume that it's not the funnest thing that people do. I enjoy, I mean, we have several policies. I've always enjoyed dealing with agents, but it's not the funnest thing people do if they're kind of going through their cafeteria plan stuff and they're like, okay, let's just get back to work. I'm missing time here. So you need to make sure that you're kind of pumping the brakes a little bit with people and that there's clear understanding that there are consequences for what you do. It doesn't mean it can't be done or shouldn't be done. I mean, it probably should be. You probably should leave your kids as your beneficiaries if you're supporting them during their minority, but you need to figure out all the mechanics of that and ask good questions.
Well, I had a situation I want to ask you about to see if it should have been handled any differently than what we did. 23-year-old worked at a HVAC company, and he put his child as a beneficiary. He was divorced, and he died in a motorcycle wreck probably like
Mm,
3 months later.
mm,
And the grandfather and his wife were taking care of the child
mhm,
because the ex-wife didn't want to take care of the child. She wanted the money, however, from the life insurance. He had $100,000 life insurance.
mhm,
And of course, the grandfather and his wife wanted the money because they were
mhm,
raising the child. And so it
mhm,
went to probate court and made the
mhm.
decision that the grandfather got it. But by the time they took their portion of it with probate court for hearing this situation, they had maybe 70.
Yeah, yeah, and that sounds consistent. I mean, that would be that's the other part of the mechanical side of it that people don't necessarily see when they just want to get in and drive off is you got to put gas in this car. And so you get to these points. I mean, I had a case recently. We had a successful appeal. We had a case open 5 years. I mean, that's too long, but we had a case open here 5 years on our caseload, and we fought it, you know, really heavy, mom versus dad thing, and got all the way through it. Won the appeal. Got appealed to the Court of Appeals. Won the appeal, did not get our attorney's fees. I mean, you're sitting out here and you're saying, well, you golly, we are at that point 30, 40,000. And that's from what I hear, that's not too bad. Okay. On 5 years from what people say, well, I spent $80,000 in 3 years, so that ain't too bad, but, I had to pay it. I mean, at one point we're talking about, maybe having a couple $100,000 in assets left in the judgment to deal with. I mean, a fifth of that goes to paying attorney's fees, and the loser don't have to pay. Okay, I mean, it doesn't always work like that. It rarely works like that. So that's a part of it. You look at that, and you have to get people in the mindset too. Is that yeah, ultimately the insurer might issue you $100,000 check, Papa, but you know there might be steps along the way that you're incurring that $20,000 and $30,000 fee. You're paying your lawyer some sort of contingency to go after, a benefit if that's allowable. You have to make those decisions. You should have to make those decisions when you've lost your son and you're raising your grandchild. You shouldn't have to make those. That's one of those things that you know, like my wife will often say, when I get to heaven, I'm gonna ask God about this. And you shouldn't have to ask about these things. You shouldn't have to operate like this, and that's not fair. And that's not your insured signed up for $100,000 and a quick check, and thought you were going to have 40-cent postage stamp in it at the end of the day, and that was not the case, and so that's not fair. So the insured themselves maintain some control over that, but I think they need some general guidance. And I've thought about this though, since you invited me to be on. It would be very easy for me as a lawyer to say, "Well, just have them contact a lawyer." Well, that's intimidating on people too. I mean, people that call us up, we can't always give them the best answer. We're rooted on helping people through litigation, and so if they don't have a case, we can't. We're probably not in a good spot just to sit there and go 30 minutes on the phone with them and give them every contingency. It's hard to get people to schedule to come in and sit down if it's something especially that's might not be a very active practice area. So it's hard to just tell people or hit Google and find lawyers to talk to this about. So that's intimidating for people. And also, too, if they do, they say, "Well, I'm real comfortable." Well, sometimes the people that they're most comfortable reaching out to are just kind of and I don't want to put any, impunity on the legal profession that I'm a part of, but sometimes people are just a retainer collector. Okay. I mean, yeah, sure, come on down, you know, drink some coffee and look at my latest hunting prize, and then we'll take care of you, babe girl. And all of a sudden, it's like, that might not have been the best approach for them because that might not have been somebody who was specialized enough and had the right touch for that situation. So it's very difficult and daunting to just tell everybody, call your lawyer about it. Plus, it also involves, even though I think you should trust lawyers and I think lawyers should be involved in a lot of things, I don't think that the typical person, they see that as the lawyering up, like the TV show. Why am I going to have to lawyer up? So it's tempting to say, go and run and ask a lawyer about it. And oftentimes it might be the right thing to do, but it's intimidating for people. So you have to understand that, probably 90+% of people are going to think, well, I trust this person. They're trying to take care of me and they're going to move on that way. And that's a difficult bind to be in when it gets serious. So don't ever hesitate, but you might not go out there and say, call a lawyer. Don't ask me. I'm just trying to tell you the truth. You might want to develop the right amount of rapport with them to where you can explain
Well,
this.
on that note, Aaron, if
And
they
not
need to
provide
call a
legal
lawyer,
advice either, not practice law with them, but say, well, this is something you might need to reach out and do.
I was going
Go
to
ahead,
wrap
sorry.
it up on that note right there. We appreciate you sitting in. But if somebody needs a lawyer, how do they get in contact with you, Aaron?
If anybody needs a lawyer, they want to reach out to me or they got further questions, my website is lakeway.law. And so our area here up in Upper East Tennessee is called the Lakeway region. And so LAKEWAY.law, LAW, not .com, not .net, lakeway.law. You can also just pump me in Google. You're going to find me there. Our number here, 423-254-5333. My email address is Aaron, that's AARON @lakeway.law. And we're here, we deal with a lot of different situations, and a big part, probably wouldn't call it a part of our practice, but a big thing that we do every day is make referrals. And, I'll get people come in here and they'll spend 2 minutes on the phone with us and we'll say, that sounds like a good situation for so-and-so whom I trust or whom I typically refer to. So
All right.
we'll
Well,
help
Aaron,
you out if it's needed.
I sure appreciate you sitting in. That's
Yeah,
very
we do
much
appreciate
needed
you.
to understand this. Rick, probably one of our better speakers, but I want to thank you so much for your time and your knowledge on that. Don't forget, go to our website, groupagenttraining.com. If you have questions for me or Rick or Aaron, be happy to help you. Go to our Facebook page. Be sure to view one of our other podcasts. We've got a bunch of them out there, and we just appreciate everybody being here. Aaron, hope to see you at a game soon, or maybe at the Macy's New Year's Day parade. I know that's my wife and y'all are talking about that. Maybe we go there to see that together. That'd be a blast.
I hope y'all enjoy it.
Or Thanksgiving.
Absolutely. Thank you for having me.
Thank you.
All right,
Thank
guys.
you,
Thank y'all. Have a great day, everybody.